Hey everyone, good to be here. My name is Paul Ramblay. I'm an estate planning attorney. Let's jump in. Let me adjust a couple of things on my screen every time I go live. I have to do that. Okay, so here we go. We're going to talk about some different ways to leave your estate to your kids. And some people will have an interest in leaving their estate to their kids and their grandkids. So we'll talk about all those differences. Welcome. If you're new to my channel, good to see you. If you're not new to my channel, like Larry, welcome back. I've been taking some time off and kind of figuring out, what my work's going to look like over the next 10 years or so. But enjoy what I do. It's good to be back. Use this channel to educate. Like to do it live. That way we can have some chat. If there's some questions, comments, experiences, we all keep it positive. Throw it in the chat. Let's jump in. Okay, a lot of people they really don't know what it means or what all the options are when they're trying to figure out, what's going to happen when they die to all of their stuff. And by stuff, I mean all of their money, their property, their home, their rentals if they have them, businesses if they have them. So I want to jump in, start with square one, and then let's talk about some of the, when you step it up a notch, maybe for more protection for the kids, more protection for the grandkids, what that stepping up looks like. So different ways you can leave your estate to your kids and grandkids. All right. And so really, as I talk about it here, this is often where I start. I've had many, many thousands of conversations with clients I've had over the last 30 something years. Most of my client conversations have been with married couples, but that doesn't mean I only help married couples. Sometimes I'll have a single person who's a client, either because they were divorced or their spouse passed away. So, and look, obviously not everybody that I have helped over the years has had children, but we're going to focus this live stream on people with children. And really, in my mind, it's that conversation with a married couple that has children. And when I have those conversations with married couples and we talk about all of the aspects of estate planning, I kind of always tell them I start at the end and work backwards, because if we start at the end, it makes some of the other questions easier to answer. So with married couples, I always tell them, let's start at the end and work our way back. I'll say something like, let's just assume, even though it's not likely to happen, let's just assume you both passed away at the same time, just to get what's on your mind, how you'd want things to go. And so a lot of married couples, or single people for that matter, who have children, their default and kind of what they're thinking in their mind is they want to leave things to their kids equally. Obviously, that sounds fair. That sounds equal. That's kind of what's in their mind. Nothing wrong with leaving things to the kids equally. And by leaving things to the kids equally, I'm going to use the term leave it to the kids equally outright. Outright means it kind of gets dumped into their lap, which is fine in many cases, as opposed to leaving it in a trust for them. We'll talk about that in a little bit. All right, so another Georgia, good to see you. Oh boy, I think this is some scammy comments we've got coming in. If they keep it up, I'm going to have to exclude them from the channel. We'll see where it goes. All right. So leaving things to the kids equally. Sometimes wills or trusts say I leave everything when I pass away to my children equally. Sometimes documents say I leave my estate to my descendants per stirpes. Let's say you have 3 kids, and the whole descendants per stirpe stuff is if one of your children, for example, dies before you and that child had children, then if you leave your estate to your descendants per stirpes, then the deceased child's share, deceased child's 1/3, if you had 3 children, would go to the deceased child's children to be split among the deceased child's children. If that deceased child had 2 children, then that deceased child's, what would have been their 1/3 would be divided equally between the deceased child's 2 children. You see that a lot. So that's really a lot of grandparents, want to have those provisions in there. Some will come into our office, not many, or have a Zoom call, and they'll have already lost a child. And so they want to make sure that the child's share goes to the child's children. So that descendants per stirpes is kind of a default. It's what a lot of people do. And some people question at the most basic level, well, Paul, I have a home and I have three kids. How in the world do you leave a home to three kids? Oh, no problem. So you leave your home and all of your other assets to your three children equally. And when it gets passed along to them, the three children co-own the home. They each own a 1/3 interest in that home. Often we call it an undivided interest in that home. It's not like one owns the kitchen and the laundry room and another owns the master bedroom and the living room and another room. They each have a 1/3 interest in the whole thing. Not that difficult to comprehend. So no problem leaving assets that may appear to be indivisible, no problem leaving that to multiple people or multiple children. Just as it's easy enough to leave shares of stock to three children. If you pass away with 300 shares of Apple stock, of course, each child's going to get 100 shares. Pretty easy, no brainer there. Obviously, if you leave money in the bank accounts to the three kids, they'll divide that, 1/3 each. No problem there. Okay, so by the way, keep coming in the chat. I see the chat and I see, the questions coming in, but I usually don't address them until the end when I feel like I've delivered the material that you've come to see. All right, so I'd say, when we talk about different ways to leave your estate to your kids, that's one way. Just leave it outright to your children equally or to your descendants per stirpes. Oftentimes, if the legal documents if they do say, I leave my estate to my children equally, the documents will expressly state, if one of my children predeceases me, then I'll leave the child share to the child's children. So that's just covering some of those what ifs that might happen. Be careful on some of your retirement account beneficiary designation forms or TOD designation, where you designate beneficiaries of investment accounts or other things. Some of those forms that you have to fill out, they often state if one of the named beneficiaries dies, then the IRA, for example, or the brokerage account, for example, would be paid to the surviving beneficiaries that are listed on that TOD form. So you got to check that out. Those beneficiary designation forms and TOD forms, depending upon what financial institution you use and what their form provides, they can get tricky, particularly if a child predeceases you. So got to be aware of that. All right, so that's I just want to leave it to my kids equally. Happens a lot. So now let's go into some of the kind of secondary circumstances that we see when people have children, perhaps even have grandchildren, and maybe they're not thinking just leave it to the kids equally for one reason or another that we're about to explain. All right, so the next scenario that we see sometimes is some parents will say, and we're not including the grandchildren yet, we'll get to the grandchildren, but some parents will say, I want to make sure this child of mine, Paul, we have three children. They'll say, we want to make sure that this child gets this particular asset, and then the rest of it can go to our children equally. So sometimes parent might say, our daughter, she's never owned her own home. She lives with us. If we don't leave her a home, she'll never have one. So we want to make sure we leave our home to our daughter and then leave the rest of our estate to our three children equally. Some people choose to do that. Now, when you leave your quote unquote house to your daughter and you have three kids, there's a decision to make on what to do with the rest of the assets. Do you leave the rest of the assets to the three children equally, which means your daughter is going to inherit more value than your other two children? And maybe you feel like, that's fair and that's reasonable for whatever reasons you have. If you think that, fantastic. Or maybe you think, that's not treating our children the same. So sometimes parents will say, we leave our home to our daughter, and we leave the rest of our estate to our three children, but we want the value of the home after we pass away to be counted as part of that daughter's inheritance so that all three children inherit the same value. You die with a $2 million estate. Your home is worth $400,000. Well, let's say you die with a $3 million estate and your home is worth, let's call it $500,000. Well, under that scenario, you'd want each child to inherit $1 million. So the daughter would inherit the $500,000 home and another $500,000 of other assets, perhaps liquid assets. And then each of the two children would also inherit $1 million of non-home assets, so they all inherit equally $1 million in value. And even if you didn't do that, and kind of in your mind you'd want that daughter to own the home after you and your spouse pass away, you're not really guaranteeing that your daughter will own the home. But if you just leave everything to your 3 children equally, your daughter inherits 1/3 of the home. She could buy out your other 2 children, buy out their 1/3 interest in the home after she gets, the cash and other assets. So there's a couple of ways to skin that cat, for lack of a better term. But anyway, and when you do leave that asset to one child and make the provision that you want the children to inherit equally in value, but you want this one child to get this one particular asset, and that asset is counted as part of that child's 1/3. If you have 3 children, you better be particular about how the value of that asset gets determined once you pass away. So maybe you provide that the executor of your will or the trustee of your trust can determine that value. Maybe they go get it appraised and they can determine that value. So anyway, there's, obviously a home and can be subject to different people their opinions can differ on the value of that home when you pass away. So probably need just to be real clear and accurate to provide a method for how that asset gets valued after you pass away. All right, so we've gone through just leaving it to the kids equally. We've gone through, I do want to leave a specific item to a specific child. Next, an issue that comes up a lot is because children sometimes get divorced. It's how can we make sure our son-in-law or our daughter-in-law never gets her hands on any of our money? Hear that a lot. So kind of a tricky issue here, but not tricky, but we've got to go through a couple of explanations to get to the bottom of it. So a few moments ago, we talked about just leaving everything to the 3 children outright. And let's say Sally is one of the 3 children. You leave $3 million. You have 3 children. Sally inherits $1 million. So the moment she inherits that $1 million, it's hers and hers only. However, if she commingles or mixes up any of those assets that she inherited with other assets that Sally may have with her spouse, and then if Sally gets later divorced, she's likely to lose some of her inheritance. So now maybe if she keeps it separate and just make sure that she always keeps her inheritance separate, she can do that herself, then maybe she by herself is doing things after you pass away to make her inheritance more divorce proof, as we say. Some parents like to add a little of that layer of that divorce protection into their estate planning documents. And when I say into their estate planning documents, it's probably the right time for me to talk about the will or trust discussions. Some people leave their estate to their survivors through their will. That's the traditional kind of old-fashioned way to do it. You leave all of the assets in your name. You write your will. That's what you see in the movies all the time. That's what's talked about and has been talked about for generations. You need to write your will. I have a will. Did they die? Did they have a will? So that's what people know. But when you leave all of your assets in your name and you have a will, then when you pass away, your assets are frozen. The will has to be submitted to the court. A judge has to validate the will, declare it's valid. Families go through a court process where a judge gets involved, ordering that assets be transferred to the appropriate heirs. And there's all other procedural aspects to that, what's called probate process. Many people complain because the probate process can be expensive. It can be time consuming. It can be an all around hassle. And in many cases, it's justifiable that they complain about that because you're dealing with, lawyer involvement, court involvement, government involvement. It can be a mess. So in the alternative to leaving your estate to your heirs through your will, some people will create their what's called revocable living trust or living trust. Some people call it living revocable trust. The idea there being create the John and Jane Doe, for example. That's the married couple who has children, the John and Jane Doe revocable living trust, and transfer those assets that were in their name that would be frozen upon their death, that would have to go through the probate process when they die, transfer those assets from John and Jane Doe to John and Jane Doe as trustees of the John and Jane Doe Revocable Living Trust. And then in that trust document, in that trust instrument, all of the what happens when John and Jane dies gets incorporated into the trust instrument. The will becomes much less important because the trust instrument governs the disposition of the assets that are in the trust. Assets that are in a trust when you die, they bypass all of that court and lawyer involvement. So the trustee that you name to handle your trust when you die or when you and your spouse die can immediately, oftentimes the day after you die, transfer the real estate to the appropriate beneficiary, sell the real estate so that cash can be distributed to the trust beneficiaries, all outside of that court and lawyer involvement. So I talk a lot about, you can do this, but you need to make sure that your will or trust does that. Your will, when you have what I call a will-based plan, you leave everything in your name and your will governs what happens to your assets when you die. Or you may have a trust-based plan. Your trust governs what happens to the trust assets when you die, and you transfer those assets to your trust, which says you can do whatever you want to with the assets for the rest of your lifetime. But by having them titled in the name of your trust, you're ensuring that those trust assets avoid the court and lawyer involvement of probate when you die. Okay, so I'll talk a lot about make sure your will or trust says this or that. By the way, if you have a trust, you'll also have a will, just in case there's any assets in your name when you die. It's called a pour-over will, so those assets go through the probate to be poured over into your trust, so your successor trustee can distribute those trust assets to your trust beneficiaries. Okay, that's a mouthful. So now here we are. Now we're back to the how to make your children's inheritance divorce-proof. There's different layers of protection that you can add. If, as I said a moment ago, you can just kind of leave assets to your children outright. It's kind of on them to protect those assets from their potential future divorce, because if they commingle those assets, those inherited assets, with other assets that they have with a spouse and they later get divorced, they'll likely lose some of the inherited assets. So what a lot of parents do is say, you know what, we have 3 children, Sally, and then child number 2 and child number 3. Let's use Sally as an example. They leave Sally's 1/3 to the Sally, I call it the Sally Inheritance Trust. And so for the rest of Sally's lifetime, all those assets will be held in the name of the Sally Inheritance Trust, really making it harder for those assets to get mixed up or commingled with other assets that Sally may have with Sally's spouse. Say that 5 times fast. And so if Sally subsequently gets divorced, Sally keeps her trust, and then Sally and Sally's spouse split the other assets that Sally and her spouse may have acquired together during their lifetime. So some people like that inheritance trust. When you do create that inheritance trust for each of your children, you'll have some decisions to make. Most people who have responsible adult children and the parents are comfortable with the child controlling the child's inheritance. But like they tell me, we like our son-in-law, we like Sally's husband, but Paul, you just never know. So in those circumstances, parents will make Sally the trustee of Sally's inheritance trust. That way, Sally can kind of do whatever she wants to with the assets, but as long as those assets remain in the trust, they won't get mixed up with other assets Sally has with her spouse. Some people want to give Sally a little more protection, either because Sally might get influenced by her husband, by her children, by someone else into doing something that Sally shouldn't do with those inherited assets if she were the sole trustee. So some people will say, well, if distributions are going to be made out of Sally's trust after we die to Sally, we want another co-trustee involved, or we want a different trustee, someone other than Sally, to say that distribution to Sally is a good idea. So there's who's going to be the trustee or co-trustee of the inheritance trust for your children if you're setting up a trust for your children in an attempt to make your child's inheritance more divorce-proof. Okay, so that's a whole aspect. Most people, when they enter the conversation, I have people all around the country, and they go to the description of my video. We offer these Zoom meetings where you'll have with me. We help people all over the country. Most people, when we start that conversation, they don't really think about making their children's inheritance divorce proof. It's not a concept that they'd ever heard of. But once we bring it up, they're like, yes, we want to have that. And so you see that a lot. That's just, you need to make an informed decision. All right. Now, maybe one other aspect to leaving things in trust for your children. I touched on it a moment ago. And really what we're talking about here is your adult children. There's a whole nother discussion to be had if you have children who are 3 years old. I'm talking about children who are in their 20s, their 30s, their 40s, their 50s. And so they're adults, and many of them are very responsible. And so we're talking about some of the ways that you can leave your inheritance to those children. But many people have children, and those parents, they're just not comfortable leaving a lump sum of money to a child, even though that child is an adult. So if that's the case, if you have a $5 million estate and you have 2 children, and the thought of leaving $2.5 million or more to one child in one big lump sum, if that scares you to death, then perhaps you should consider leaving that child's or both of your children's inheritance in a trust for them, because leaving it to them in a lump sum is not in their best interest. Maybe you're thinking, I'd want that inheritance to last for the lifetime of my child. I don't want to see it blown in the first couple of years on vacations and trucks and boats and all those other things that parents say that their children might spend the money on. So maybe you leave assets to a trust. And when you do, and you'll name someone other than your child as the trustee, there'll be several decisions that you need to make. Under what circumstances can your child get distributions from that trust? Who's going to be the trustee? How long will that trust last? So lots of decisions there on if you're trying to protect an adult child from themselves because they might not make good money decisions, or they might get influenced, or they might just squander the inheritance, then lots of decisions to be made when you leave an inheritance to a trust for a child like that, to ensure that that inheritance benefits the child for the rest of their lifetime. So you'll make decisions of things like, well, let's leave it in trust for them, allow them to get distributions for certain needs. Then when they're 60, they can have it then. Or let's make sure they get a monthly amount every month until their inheritance runs out. And then maybe you'll say, let's make sure that monthly amount goes up a little bit. And maybe it's adjusted for inflation after we pass away and once that child starts getting distribution. So again, lots of decisions there. We can talk about that on a Zoom call if that's appropriate. All right, now let's enter the grandchildren into the conversation. You might say, why would we do that? Because some people, quite frankly, tell me that they like their grandchildren more than they like their children. Oh, by the way, my first grandchild is due in about 1 month exactly. So we're excited for that. It's going to be a granddaughter, and can't wait. So anyway, let's say you're a parent or a grandparent. Yeah, you're welcome, Alicia. I was hoping somebody would tell me that. Anyway, enough on that personal stuff. Now, let's say you're a parent, and look, maybe you don't like your grandchildren more than you like your children, but many reasonable grandparents want to include somehow their grandchildren into their estate plan. Some people just want to kind of a token acknowledgement. And look, every number that I throw out there is relative. But some grandparents will say, well, I want to leave, $10,000 to each of my grandchildren. That's something that I'll call, it may be a big sum for a lot of people, but I'll call that a token acknowledgement and leave the rest to the children equally. Or some parents, and grandparents feel like, I want to make sure I leave something to the grandchildren, because if I just leave it to my children, I don't know that my money will ever make its way to the grandchildren, because my children may spend it all before they die and none of it will ever get to the grandchildren. So a lot of people have told me that. A lot of people have told me, I want to set some money aside for the grandchildren because I want to make sure that they can get, a college education, or make sure they can buy their first home, or whatever reason those grandparents may have. So it is common for grandparents to say, yeah, let's have a discussion. Sure, we want to leave, and many grandparents say we want to leave the bulk of our estate to our children, but we also want to include our grandchildren. In fact, talking personal stuff, my own grandmother left me a few shares of stock when she died in 1972. I was 7 years old, went into a custodial account, kind of went into my name at age 18, but it played a big role in me being able to go to college, go to law school, went to Boston University after law school, earned a master's degree in tax law. So big deal, kind of a big deal that my grandparents did that. I don't know I'd be where I am today if my grandmother had not done that for her grandchildren. So anyway, so enough on that, but let's go to how to do it. All right. And again, we'll talk about we're not talking about the token acknowledgement. I leave $1,000 to each of my grandchildren. I leave $10,000 to each of my grandchildren and the rest of my children. That's what I call a token acknowledgement to the grandchildren. But let's say, grandparents are sitting there with a $4 million estate, and they want to figure out, what they should do for the grandchildren. And so people will tend to either leave and let's say they have, three children and 6 grandchildren. People will either wind up, as I walk them through the conversation, they'll either leave a fixed dollar amount for each of the grandchildren. So, for example, grandparents may say, when we pass away, we leave $100,000 to each of our grandchildren, and the rest of our estate they leave to the children. So, for example, under that hypothetical $4 million couple, they leave $100,000 to each of their 6 grandchildren. That's $600,000 of their estate. But then they leave, the rest, whatever that number will be when they die. But if they died that day, it'd be $3.4 million to their children. That's leaving the bulk of what you have to your children, but also leaving something to your grandchildren. In fact, these days, when the goal is to make sure they get a good college education, they do the math in their mind, and they kind of feel like they have to leave more than $100,000 to each of their grandchildren because of the education costs these days. I can certainly vouch for education costs. My wife and I have 5 kids, 33 down to 24. All 5 not only went to college, but all 5 went to law school. 3 of them are done, and 2 are still in their second year of law school. So that $100,000 bequest would not have covered it all. Would have helped, but would not have covered it all. So anyway, my point here is it's common for grandparents to say, I leave a set amount. I used in my example $100,000, but I've had many grandparents increase that number to $250,000 for each grandchild. Some grandparents leave a specific amount to the grandchildren with the remainder to the children. Now, I'll get some comments when a grandparent says, I want to leave $250,000 to each of my 6 grandchildren. You do the math, that's $1.5 million. And they're sitting on maybe a $3 or $4 million estate. And there's this concern that I see creep into the back of their mind. What if we spend a big chunk of what we have, and when we die, we'll only have maybe $1 million or so? Legitimate concern. And so if that were the case, then the grandchildren who received a specific amount, their amount would be satisfied first, and the children wouldn't get anything because the $1 million that was left behind did not cover the $250,000 that was left to the 6 grandchildren, $1.5 million. So that's a concern that some grandparents have. If they put too big a specific number to the grandchildren and they spend it all, then there's not going to be nothing left for the children. Most of the time that doesn't happen unless there perhaps is some major long-term care need where an elderly person might spend $200,000 or $300,000 a year on their care, and gradually depleting the estate. Don't see that often, but see it sometimes. Okay, so to prevent the children from winding up with nothing, then you have to go to I leave this percentage to the grandchildren and I leave this percentage to the children. Some grandparents will say, we have 3 children, we have 6 grandchildren, so let's leave 50% of our estate to be divided among the 6 children, and let's leave 50% of our estate to be divided among the 3 children. So each child inherits more, twice as much more as each grandchild, because they left the 50% to the 6 grandchildren. And so, each grandchild, uh, you know, you figure, you know what I mean? The children get more than the grandchildren when you're looking at each person. So, or some grandparents will say, we've got 3 children and 6 grandchildren. That's 9 people. Let's just divide everything 1/9 each. So that, I would say, that's not common, but if that's what grandparents make an informed decision and do that, fantastic. But I would say more common than not that might be kind of too much for the grandchildren. Again, every situation is unique. Everybody can make their own decision. I just don't see people leaving the largest chunk to the grandchildren. Now, I will say, however, sometimes people tell me, Paul, our children, they're well off. They did better than we did. They have incredible careers. They've saved, and they don't need our money. In fact, some grandparents tell me, Paul, our children came to us and said, don't leave us the money. Leave it to the grandkids. So you see that sometimes. So again, every situation is different. All right, now, couple of situations that we got to talk about on the leaving it to the grandchildren. I'm going to assume, we're talking about, let's say, a 70-year-old couple. The children are probably in their around 40 or in their 40s. The grandkids, probably, maybe infants through teenagers. So if you're going to leave a big chunk like that, or really if you're going to leave any amount to a minor grandchild, you got to make sure you leave it to them in a trust. Many grandparents will say, well, Sally has 2 children, so the $250,000 I'm going to leave to Sally's children. Sally's children are 7 and 9 right now. So let's make sure if, when I pass away, $250,000 goes to each of Sally's 2 children. If those children aren't yet 25, and I made up that number, but if Sally's children are not yet 25 when I pass away, let's leave it in a trust for them. Let's name Sally, the mother of the children, as the trustee. And then, Sally can use it for their needs. And then whatever's left when they're 25, it can be turned over to them then. Or quite frankly, if they want the divorce protection for the grandchildren, then Sally's the trustee until the grandchild reaches the age of 25. And then the grandchild becomes their own trustee to keep it, separate from other assets a grandchild may have in the future with a grandchild's spouse. Okay, so we got to talk about, if you're leaving things to young grandchildren, it should be left in trust for them. A couple of the other issues are sometimes, we'll work with grandparents who have 3 children, and one child of theirs has 4 children, one child of theirs has 2 children, and one child of theirs has no children. So if you're going to be leaving $250,000 to each grandchild and the rest to the 3 children equally, that one family, the child who has 4 children, will inherit more assets. That family will inherit more assets. Many grandparents say, so be it. We just can't do anything about that. We want to leave $250,000 to each of our grandchildren. And yes, if that family inherits more, so be it. It's just, that's the way it's going to work out. So anyway, you just have to be aware that there's issues involved there, and make sure that you make the decisions that you deem are appropriate and fair. Okay, so let's keep going here. There are some issues with retirement accounts, particularly, if you want to leave some of that to grandchildren, because generally speaking, there's all kinds of income tax rules and on required minimum distributions that have to come from your inherited IRAs after you pass away. But essentially, if your ultimate goal is that the least amount of income tax be paid after you pass away from the distributions from your traditional IRAs or 401ks, then you really have to expect that those beneficiaries will receive all of that money within 10 years after you pass away. So maybe it's more appropriate to leave your IRAs to your mature 40-year-old children, as opposed to leaving all or a portion of your IRAs to your less than mature, because they're 7 years old, grandchildren, because they're going to have to get all of that money if you want to make sure the income taxes are minimized. The 7-year-old would have to get all that money by their 17th birthday. Yes, you may be thinking that if it goes to a minor, they have until 10 years after they're 21, but that rule only applies if you leave your IRAs to children. That 10-year period starting at age 21 doesn't apply when you leave your IRAs to grandchildren. A lot of people aren't aware of that. So anyway, there's some things you have to consider, particularly if you want to leave money to grandchildren, on how to do your beneficiary designations on your retirement accounts. Lots of other estate. So all we've addressed thus far is just how to leave assets to your kids, or how to leave assets to your kids and your grandkids when you're dead. So, or when you and your spouse have both passed away. That's just one aspect that you deal with in the estate planning process. There's lots of other estate planning issues that involve your kids. There's who's going to be the executor of your will. You may say, well, I'd want my spouse to be. Well, your spouse may not be alive when you die. So you always have to name backups to your spouse on all of these designations. So which child or children, or do you even designate children at all to be the executor of your will, the successor trustee of your living trust? If you go that route, who's going to have financial power of attorney for you to be able to handle your money if you're alive, but you're incapable at some point during the rest of your lifetime due to injury or illness or for some other reason, dementia? If you get to a point where you're not able to handle your money, your power of attorney makes it easy for the people that you designate in your power of attorney to be able to transact your IRA and your bank accounts that are in your name without having to go through a court process to have a judge designate that you're incompetent and have a judge designate a legal guardian. That guardianship proceeding is an absolute nightmare, and most families can avoid that by having these powers of attorney in place. So many people are not only designating their spouse as having power of attorney, but you put a backup to your spouse, and that's often one or more of the adult children. And if you do designate more than one, do you designate that they have to act together, which can be an administrative difficulty depending upon what financial institutions they have to deal with? Or if you appoint more than one child, do you say that either of them, for example, can transact on your behalf? All the healthcare decisions, you'll be, as part of your estate plan, you'll be signing various healthcare documents. Some states call them healthcare powers of attorney, some healthcare directive, some advanced healthcare directive. Some states call it healthcare proxy. It's if you're not able to make your medical decisions, who do you want to be able to talk to the doctors for treatment decisions? Go get your medical records, all those things. Most people, again, married people, name their spouse first and one or more of the children as the backups. There's all kinds of other issues we haven't addressed, like special needs trusts. If you have a child who's receiving certain government benefits and you're concerned that by leaving them an inheritance, that would jeopardize their ability to continue receiving those government benefits that are means-based, then we have to start talking about special needs trusts and leaving assets to children in a way that they don't get penalized from or they don't lose their government benefits. So all kinds of other issues there. Other issues in estate planning that we'll get to in other discussions: how to leave assets to your spouse. We didn't talk about that. Really, the whole estate tax thing, which we're almost to 2025, where the estate tax exemption is going up to 13.99 million. And who knows what's going to happen in 26. I've done lots of video presentations on that, gifting as well. And then some people want to leave trusts, not just for their children's lifetime or even for their grandchildren's lifetime. Some people want to leave assets in trusts for as long as they can, even for their great grandchildren's lifetime. And sometimes those great grandchildren don't exist yet. So there's lots of issues, and all states have certain limitations on how long a trust like that can last. But we deal with it quite a bit when people have maybe a kind of a family property that they want everybody to enjoy for generations to come. So we see a lot of people requesting that certain assets be held in trust for a very long period of time after they pass away. Okay, all good stuff there. Let's see what we've got here on some of the comments. Hang on. This is sometimes the best part. Cheapest, Darlene, how you doing? Carter, cheapest way to leave 40 acres to daughter and grandchildren. And has been in family for generations. We are on a fixed income. Well, you're probably going to have to get with somebody like me and create a trust and designate maybe your daughter to be the trustee of that trust after you and your spouse pass away. And because you want this property to stay in the family for generations, maybe you designate a grandchild to be the backup trustee. Maybe you give your daughter down the road the ability to designate the trustee of that trust after your daughter passes away. So really, that how do we keep property in the family for generations? I think one of the most important appointments and one of those important decisions is, yes, you're going to be leaving things in a trust. But the selection of who that trustee is, or how that trustee will be determined, or how will a trustee be selected in the event of a vacancy in the future in the office of the trustee? Those are some of your more important decisions. Great to see Susie. Of course, I already mentioned Larry. Great to see Larry. Alex, speaking grandchildren, can you talk about the generation skipping tax? Yeah, I'll touch on it briefly. Good question, Alex. Very, very generally speaking, the government doesn't like the government. I'll say this, just say what I'll say what came to my mind. If you're really wealthy, what is really wealthy? Well, for purposes of the estate tax, if you're a married couple and you die in 2025, let's assume you're going to make it through 2024. There's only 20 days left. In 2025, the federal estate tax exemption is $13.99 million. Let's call it $14 million. And so really each spouse has an estate tax exemption, 14 million. So that's 28 million. And let's say you're in that range or above, maybe even a lot higher, and that's okay. The government really wants you to leave all of that to your children. And yes, the portion over 28 million would be taxed at 40%. That's our federal estate tax. They want you leaving all of that to your children, so that when your children die, then the government gets that estate tax when your children die, and they attempt to leave it on to the next generation, your grandchildren. So the government really doesn't like the idea of you leaving a significant amount of assets directly to your grandchildren, because they won't collect any of the estate tax when your children die. So there's all kinds of limitations on your ability of how much you can leave to your grandchildren without an extra tax called the generation skipping transfer tax. I'm gonna stop at that for now, and maybe we'll have another video just on the generation skipping tax. All right, what is it, and in what situations it applies? Yeah, it generally applies. This is maybe oversimplifying things, but for 2025. Generally applies if couples try to leave more than $28 million to people who are two generations or more younger than them. So that knocks out many people from having to worry about the generation skipping tax. But when it does apply, it's a whammy. So if it does apply, need to address it. All right, Alicia, that's what I'm concerned about. Kind of older son may be married before my younger son. Older son may be married. Okay. Alex, also, what is your experience with Fidelity Trust Company, Vanguard Trust Service, Sandwich Schwab? A lot of experience, Alex, with all three of those trust companies. Boy, I probably ought to have a session just on naming a corporate trustee as a trustee. I don't even know how to summarize it, but if I tried to summarize it, I must say, those large Fidelity, Vanguard, Schwab trust companies, they serve a role and they serve a niche. And that niche is usually you've accumulated some wealth, and for one reason or another, you'd like to leave some assets behind for your family or others in a trust, and you want that trust to be professionally managed. You don't want to impose that duty on a family member who has no experience. You'd prefer, or there may be some family dynamic issues where you don't want to name family members as trustees of a trust that you leave behind. So that's when you need to consider, should you name a corporate trustee? First question people often ask, well, are there fees involved in naming a corporate trustee? And the answer is, of course they are. They may not be as much as you think, and it all can depends on how much the assets are. And so I've had experience with all of those trust companies. And so, the planning all has to be done correctly to designate those corporate trustees as trustees. So there's a lot involved in that. Now, the more I think about it, the more I should do a live stream just on corporate trustees, maybe even get a representative of one or more of those organizations on with me. Chelsea, great to see you too. Like the emoji. Alicia, I already saw that one before. Good. My first was a little girl. Also, I think you're talking about grandchild. Good. Are all of these trusts separate? Well, maybe my best answer, Alicia, is probably. So if you have 3 kids, Sally, John, and Timmy, and look, there's so many different kinds of trusts, but you like the idea of making it divorce proof. You're going to leave 1/3 of your assets to the Sally Trust, 1/3 of the trust to the Timmy Trust, and 1/3 to the John Trust, or whatever the names are. So those are going to be 3 separate trusts after you pass away. And they can either be what I call standalone trusts, or they can be sub-trusts within your revocable living trust instrument. So a lot going on there. Okay. Or percentage. Congratulations. Welcome. Okay, good. Hey, I'm getting some love for the, for little granddaughter who's coming next month. I'll have to let y'all know when it happens. Step up in basis. Okay. So yeah, done a lot of speaking about step up in basis, David Montgomery, but yeah, assets that are in your estate, they get a step up in basis, which can be a significant tax benefit over you transferring assets to your heirs before you die, and they get a carryover basis. So the step up in basis, it eliminates capital gains tax on all of that appreciation during your lifetime if those assets are included in your estate and you leave them to your heirs. More on that later. Bella says, I have 2 sons. Would it be better to put my house in one trust and the rest of money equally, but request that my son of the house to estimate the house and give the half back to his brother? Great question, Bella. I'd probably ask you a few more questions about, what are you trying to accomplish and why are you trying to accomplish it? So again, we brought some of that up in our earlier discussion. Good question. Can Roth be in a trust? It can't be in a trust while you're alive, David, but you can name a trust as a beneficiary of an IRA or a Roth IRA. But if you want the beneficiaries to be taxed on that traditional IRA money at their ordinary income tax rate, as opposed to the higher trust tax rates, you have to provide that those funds are going to come out of that trust within 10 years after you both pass away, if you're leaving those assets to children or grandchildren, or they are the beneficiaries of trust. You got a lot more flexibility with Roth IRAs because there's not that income tax hit like there is with a traditional IRA. So you've got more planning flexibility on leaving Roth IRAs to a trust. Susie, what in the heck is that emoji? But I like it, even though I'm not really sure what it is from the children. Do they need to be separate? Probably. Yeah, probably a trust for the children, trust for the grandchildren. I guess, Alicia, I'd have to ask more questions. You're welcome very much, Alicia. April, yes, please keep me posted where you can talk about. So I'm going to, in the next couple of days, I'm going to schedule all of my upcoming live streams, really probably for the rest of the year. So you can go to my channel and you'll see scheduled live streams. Teddy says, my daughter wants to own the farm and we have a son who can wait for inheritance. How do we pass the farm before death? Well, there's a lot going on there, Teddy. Depends on the value of your estate. If there's no estate tax concerns, maybe it's better that your daughter inherit the farm when you pass away in order to get the step up in basis on the farm. You could give the farm to your daughter now and then let your son inherit things when you pass away. So some of your strategy may be based on what are the tax considerations of either giving your daughter the farm now versus later. Is your daughter living in the farm now? That might be a consideration. So all those things, lots goes into the Do I go ahead and transfer particular assets to my children before I die, or do I wait and just let them inherit them when me and my spouse pass away? It's a great question, Teddy. I just need to know more. All right, great session here today, guys. Feel free to check the channel for scheduling. I'm going to let you go now and let you enjoy the rest of how can I protect my Roth IRA from Medicaid spend down. Man, you threw that. What? Okay, I'll first say some states count the value of both your traditional IRA and Roth IRA as a countable asset. And so it's counted as part of the assets that you own. If you own more than $2,000, if you're single, then you're not qualifying for Medicaid. You got to spend it down. Other states say the IRA is not a countable asset, but the required minimum distributions are income that you've got to spend. This is a very blanket statement, but I will say, if you're sitting on $1 million IRA and your state is one of those where the IRA is a countable asset, you probably got to just tell yourself, I'm not a future Medicaid recipient. I'm going to be a private pay patient if I need care in the future, because what you'd have to do is take the $1 million out of your IRA, pay income tax on all of that, and then transfer those after-tax proceeds out of your name. Nobody wants to do that. I can't blame them. It would trigger probably a $400,000 income tax bill. So a big one there. Can a trust account be with cash on it? Really, a trust account could be open with $1, particularly if an individual is the trustee, like a family member. Now, other corporate trustees, somebody asked earlier, what about Fidelity Trust Company, Schwab Trust Company, Vanguard Trust Company? They won't even accept the position as trustee unless the trust assets exceed a certain amount. It might be $1 million. I'm pulling that number out of thin air, because their fees are based on the value of the assets. But when you have an individual as a trustee, all those concerns go by the wayside. All right, Susie, I missed you being on my videos. All right, I'm going to end it for the second time. We'll see you guys. Great seeing you all in the chat. So surprised to see you all today. Have a great day.